Hello everybody, Andrew Reed here with part 13 of my study guide for the upcoming NCA exam on constitutional law. So today we're going to talk about freedom of conscience and religion, and this is going to be a long one, so buckle up, let's get started. So in the Charter, Section 2A says everyone has the following fundamental freedoms: the freedom of conscience and religion. So the first case in the NCA syllabus, which is what we are following along with these case briefs, is Syndicat Northcrest. So the background here: a religious claim by the appellants for the setting up of a sukkah for 9 days a year in pursuit of their religious beliefs on their co-owned property. And this is under the Quebec Charter of Human Rights. Now, note that these are used interchangeably. So the federal charter, the Quebec Charter, they resolve these in the same way, so they say. So in this case here, in Syndicat, after Mr. Amsalem put up his sukkah in September of 1996, then the syndicate of the co-ownership requested its removal, claimed it was in violation of a bylaw, and because the bylaw said, as part of this co-ownership, you can't have decorations or alterations, constructions on your balcony. Pretty common bylaw. The Quebec courts denied the claim by the appellants, and it went on to the Supreme Court, who says, with respect, he would allow this appeal. So after defining the scope of freedom of religion and its infringement, he finds that their religious freedom under the Charter had been infringed by the declaration of co-ownership. The big issue here was whether the appellant's rights had been infringed by the effects of the declaration of co-ownership, and if so, whether that refusal by the respondent to permit the setting up of these religious shelters was justified by its reliance on the co-owner's rights to enjoy property and their rights to personal security. And finally, whether the appellants waived their rights to freedom of religion by signing this declaration of co-ownership. A couple of rules that were ascertained from this case. From the Charter itself: every person is the possessor of the fundamental freedoms, including freedom of conscience, freedom of religion, freedom of opinion, freedom of expression, freedom of peaceful assembly, freedom of association. I believe that's wording from the Quebec Charter. From the Big M Drug Mart case, freedom means that no one is to be forced to act in a way contrary to his beliefs or his conscience. And then from R.V. Edwards' Books and Art, the purpose of Section 2A in the Charter is to ensure that society does not interfere with profoundly personal beliefs that governs one's perception of oneself, humankind, nature, and in some cases, a higher or different order of being, and that those beliefs in turn govern one's conduct and practices. So society should not interfere with those beliefs, is coming from that case. Claimants seeking to invoke freedom of religion should not need to prove the objective validity of their beliefs, in that their beliefs are objectively recognized as valid by other members of the same religion, nor is such an inquiry appropriate for courts to make. That's from Funk and Manitoba Labor Board. Next rule: if anything, a person must show sincerity of belief, and not that a particular belief is valid. It just needs to be sincere. This is from Edwards' Books. Finally, from this case, a test has evolved. The first step in successfully advancing a claim that an individual's freedom of religion has been infringed is for a claimant to demonstrate that he or she sincerely believes in a practice or belief that has a nexus with religion. The second step is to then demonstrate that the impugned conduct of a third party interferes with the individual's ability to act in accordance with that practice or belief in a manner that is non-trivial. So lots to break down there, which they do in their analysis. So speaking of analysis of freedom of religion in this case. The court says religion is about freely and deeply held personal convictions or beliefs connected to an individual's spiritual faith and integrally linked to one's self-definition and spiritual fulfillment. the practices of which allow individuals to foster a connection with the divine or with the subject or object of that spiritual faith. So as you can see, this is a very broad definition of religion. So the test that comes from the Syndicat case is at the first stage of a religious freedom analysis, an individual advancing an issue premised upon a freedom of religion claim must show the court that 1, he or she has a practice or belief having a nexus with religion, which calls for a particular line of conduct, either by being objectively or subjectively obligatory or customary, or by, in general, subjectively engendering a personal connection with the divine or with the subject or object of an individual spiritual faith, irrespective of whether a particular practice or belief is required by official religious dogma or is in conformity with the position of religious officials. And 2, that he or she is sincere in his or her belief. Only then will freedom of religion be triggered, according to this case. So that said the judge, well, a court is not qualified to rule on the validity or veracity of any given religious practice or belief, or to choose among various interpretations of belief. It is qualified to inquire into the sincerity of a claimant's belief, where sincerity is in fact at issue. So it is important to emphasize, however, that sincerity of belief simply implies an honesty of belief, which is up to the fact finder, generally, so it appears. So it's important to underscore that it is inappropriate for courts rigorously to study and focus on the past practices of claimants in order to determine whether their current beliefs are sincerely held. So they can't look at the past to determine whether the current beliefs are sincerely held. Over the course of a lifetime, individuals change, and so can their beliefs. Once an individual has shown that his or her religious freedom is triggered, as outlined above, then a court must then ascertain whether there has been enough of an interference with the exercise of the implicated right so as to constitute an infringement of the freedom of religion. Section 2A of the Canadian Charter prohibits only burdens or impositions on religious practice that are non-trivial. The respondent in this case has argued that the rights of the co-owners to peacefully enjoy property and their right to personal security limit the exercise of the appellant's religious freedom under the circumstances. This judge found that the appellant's rights to freedom of religion were significantly impaired, and that the impact on the respondent's rights to enjoy their property and personal security is at best minimal. That infringement was minimal, and could not be construed then as validly limiting the exercise of the appellant's religious freedom. The trial judge in this case felt that Mr. Amslam, one of the appellants, sincerely believed that he was obliged to set up a religious shelter on his own property, thus triggering his freedom of religion protection, according to the first step in the analysis created by this case. Sincerity of belief at the relevant time is the governing standard to ensure that a claim is honest and not just made up. And then a rigorous examination of past conduct cannot be determinative of sincerity of belief. So the proper test then would be whether the appellants sincerely believe that dwelling in or setting up their own individual religious shelter is of religious significance to them, irrespective of whether they subjectively believe that their religion requires them to build their own religious shelter. This is because it is hard to qualify the value of religious experience. Religious fulfillment, by its very nature, is subjective and personal. To some, the religious and spiritual significance of building and eating in one's own religious shelter could vastly outweigh the significance of a strict fulfillment of the biblical commandment of dwelling in a sukkah that, in and of itself, would suffice in grounding a claim of freedom of religion. So, if this appellant sincerely believes that he's obligated by the Jewish religion to set up and dwell in his own religious shelter, then a prohibition against setting that up obliterates the substance of his right let alone interferes with it in a non-trivial fashion. And suggesting that he have a communal shelter to go to is simply not an option. So his right is definitely infringed per that analysis. The burdens placed upon the appellants as a result of the operation of the impugned clauses, by requiring them to celebrate the holiday by going to other people's houses and using their religious shelters, are substantial. Preventing them from building their own is definitely a non-trivial interference with the protected rights to dwell during this festival, which they all acknowledge they sincerely regard as a religious requirement. So the result is that the impugned stipulations in the declaration of co-ownership do in fact infringe upon the appellant's freedom of religion. Against the appellant's right, so the respondent, the syndicate, is claiming that the potential setting up of these shelters on the balconies is going to interfere with their rights to the peaceful enjoyment of their property and to personal security. Both are protected rights under the Quebec Charter, respectively. That, according to them, justifies this blanket prohibition against setting up these shelters. And the respondent claims that the co-owner's rights to personal security have been implicated because balconies are fire escape routes. You block the balcony, you block the fire escape route. So that's why they feel like their request is valid, saying that the presence of these shelters affects their economic interest and their security interest and the beauty of the property. This judge says even if you were to consider the possibility that the economic value of the property might decrease if a substantial number of co-owners were allowed to set up these shelters for a lengthy time period during the year, any drop in value caused by the presence of a small number for a period of 9 days each year would undoubtedly be minimal. Consequently, in this case, the exercise of the freedom of religion outweighs the unsubstantiated concerns about the decrease in property value. Protecting the enjoyment of the property by preserving the beauty of the balconies and enhancing the harmonious external appearance of the building cannot be reconciled with a total ban imposed on the appellant's exercise of their religious freedom. Although residing in a building with a year-long, uniform, and harmonious external appearance might be the co-owner's preference, the potential annoyance caused by a few shelters being set up for a period of 9 days each year would be trivial infringement to them. They also say that it's a fire hazard, you're blocking an escape route in cases of emergency, and the judge here says if these concerns were actually established and that there were security concerns, then it might be appropriate to have a limit there on the exercise. But he says, however, the appellants made sure to prove, they proved that they're not going to block any doors, would not obstruct any fire lanes, and would pose no threat to safety or security in any way. And so it's necessary that they do conform as much as possible with having proper aesthetics of the property, and they acknowledge that they would attempt that. So then the respondent contends that, okay, all that being said, the appellants waived their rights to freedom of religion and implicitly agreed with the terms of the bylaws when they signed the Declaration of Co-Ownership. And so therefore they must comply with the impugned provisions, including the general prohibition against decoration or constructions on balconies. So basically waiving their fundamental rights by signing. The judge says whether one can waive a constitutional right like freedom of religion is a question that is not free from doubt. He cites 6 cases on either side of that argument. But he goes on to say that even assuming that an individual can theoretically waive his or her right to freedom of religion, he believes that a waiver argument or something similar cannot be maintained on the facts of this particular case because while he's saying that they're completely prohibited, there's actually a clause that makes it not an absolute prohibition. It permits these covering and closure of balconies with consent from the co-owners. So that just is an ambiguity that obviates to this judge any question of a possible waiver or implicit agreement. But even all that aside, even if that wasn't the case, a waiver of any right must be voluntary, says a judge, freely expressed, and with a clear understanding of the true consequences and effects of so doing it in order to be effective. And that a right holder who has no other choice but to renounce a right cannot be said to have truly waived his or her right. And since the appellants did not have a real choice here, it would be incorrect to conclude that they voluntarily and validly waived a fundamental right. And that, at minimum, a waiver of a fundamental right, such as freedom of religion, even if that's possible, need not only be voluntary, it must be explicit, express in writing, specific in clear terms. So not only would a general prohibition on constructions, such as the one in the Declaration of Co-Ownership, be insufficient to ground a finding a waiver, but so would any document lacking an explicit reference to the affected charter right. Okay, lots packed in to the Syndicat case. Next of three cases is reference re same-sex marriage. A little bit shorter, thankfully. So issue here, whether Section 1 of this proposed legislation for same-sex marriage is consistent with the guarantee of freedom under Section 2A of the Charter. So it's argued here that the effect of this act, the Same-Sex Marriage Act, may violate freedom of religion in three ways. So that this act is going to have an effect of imposing a dominant social ethos and will thus limit the freedom to hold religious beliefs to the contrary. The proposed act will have the effect of forcing religious officials to perform same-sex marriages, and that the proposed act will create a collision of rights in spheres other than that of the solemnization of marriages by religious officials. So a couple rules are cited in this case, a few rules. The potential for a collision of rights does not necessarily imply unconstitutionality. The collision between rights must be approached on the contextual facts of actual conflicts. So the first question is whether the rights alleged to be in conflict can be reconciled from the Trinity Western University case. Where the rights cannot be reconciled, a true conflict of rights is made out. In such cases, the court will find a limit on religious freedom and then go on to balance the interests at stake under Section 1 of the Charter, which is the Oakes test. This is from the case of Ross. In both steps, the court must proceed on the basis that the Charter does not create a hierarchy of rights, from the De Gennis case, and that the right to religious freedom enshrined in Section 2A of the Charter is expansive. Let's break it down with the analysis. So the first allegation of infringement says, in essence, equality of access to a civil institution like marriage might not only conflict with the views of those who are in disagreement with this, but might also violate the legal rights of those who are in disagreement with this. This amounts to saying that the mere conferral of rights upon one group can constitute a violation of the rights of another. This argument was discussed in this case and was rejected there and is rejected here. The first question is whether the rights alleged to conflict can be reconciled. So they encountered difficulty right at this first stage then, because this act has not even been passed, this is a reference question, much less implemented. Therefore, the alleged collision of rights is abstract, no factual context. In such circumstances, the court says it's improper to assess whether the act, if adopted, would create an impermissible collision of rights in yet undefined spheres. The court notes that should impermissible conflicts occur, the provision at issue will by definition fail the justification test under Section 1 of the Charter, and then will be of no force or effect under Section 52 of the Constitution Act. In this case, the conflict will cease to exist and is a moot point. So the concern here then is that if the proposed act were adopted, religious officials could be required to perform same-sex marriages contrary to their religious beliefs. Absent state compulsion on religious officials, this conjecture, says the court, does not engage the Charter. If a promulgated statute were to enact compulsion, we conclude that such compulsion would almost certainly run afoul of the Charter guarantee of freedom of religion, given the expansive protection afforded to religion by Section 2A of the Charter, and that it also seems apparent that absent exceptional circumstances, which we cannot at present foresee, such a violation could not be justified under Section 1 of the Charter either. The question the court is asked to answer is confined to the performance of same-sex marriages by religious officials. Concerns were raised about the compulsory use of sacred places for the celebration of such marriages and about being compelled to otherwise assist in the celebration of same-sex marriages. The reasoning that leads the court to conclude that the guarantee of freedom of religion protects against the compulsory celebration of same-sex marriages suggests that the same would hold true for those concerns. Back to the question, the court says, absent unique circumstances with which they don't wish to speculate on, the guarantee of religious freedoms in Section 2A of the Charter is broad enough to protect religious officials from being compelled by the state to perform civil or religious same-sex marriages that are contrary to their religious beliefs. Okay, which makes sense in some ways. Final case, Mouvement L'Equo Québécois v. Saguenay, 2015. The issue, whether practice of members of municipal council that is regulated by bylaw and that consists of reciting prayer at the start of each meeting in a council, is in breach of the principle of religious neutrality of the state and results in discriminatory interference with freedom of conscience and religion. And if that is the case, then whether the remedies granted by the Human Rights Tribunal were appropriate here. So here's the background. The appellant regularly attended public meetings in the municipal council in the city of Saguenay. At the start of each meeting, the mayor would recite a prayer after making the sign of the cross, while saying in the name of the Father, the Son, and the Holy Spirit. The prayer also ended with the sign of the cross and the same words. Then, councilors and city officials would cross themselves at the beginning and the end of the prayer as well. There's a Sacred Heart statue in the chambers. It had a red electric light. There's a crucifix hanging on the wall. So S, who considers himself an atheist, felt uncomfortable with this display, which he considered religious, and he asked the mayor to stop the practice. When the mayor refused, S complained to the commission, to the tribunal. He argued that his freedom of conscience and religion were being infringed against the Quebec Charter, which again is judged the same way as the federal charter. And he asked, the S asked that the recitation of the prayer cease and that all religious symbols be removed from council chambers. So the tribunal granted the application, finding that the prayer was, when considered in light of its context, religious in nature, and that the city and its mayor, by having it recited, were showing a preference for one religion to the detriment of others, which constituted a breach of the state's duty of neutrality. The tribunal also concluded that the prayer and the exhibition of religious symbols resulted in interference with S's freedom of conscience and religion that was more than trivial or insubstantial, and that the interference was discriminatory. So it declared the bylaw inoperative and invalid. It ordered the city and the mayor to cease the recitation of prayer, to remove all religious symbols from the rooms, and it awarded $30,000 in compensatory and punitive damages to S. The tribunal refused to award the reimbursement of extrajudicial fees, however, because it didn't feel like the city and the mayor were guilty of improper use of procedure. So this was appealed, and the Court of Appeal allowed that appeal. In the Court of Appeal's opinion, the question of the religious neutrality of the state was a matter of importance to the legal system that required the application of the standard of review of correctness. So it held that the prayer at issue expressed universal values, could not be identified with a particular religion, and that the religious symbols were works of art that were devoid of religious connotation and did not affect the state's neutrality. According to the Court of Appeal, S had not been discriminated against on the ground of freedom and conscience and religion, and if there was an interference, it was trivial or insubstantial. The appellant of the Court of Appeal, S in this case, says there is in this case proof of discrimination. That is, 1, a distinction, exclusion, or preference flowing from that practice in the bylaw that is based on a ground listed in the bylaw and has the effect of nullifying or impairing S's right to the full and equal exercise of his human rights and freedoms. But the respondents countered that the authority for the recitation of a prayer such as this, and for regulating by means of a bylaw is it's the right of the city, and because it's their freedom of conscience and religion to do so, and that S's right is therefore not impaired. Conclusion here, the appeal should be allowed, as in the Supreme Court, says the appellant's position must prevail, S's position must prevail. Sponsorship of one religious tradition by the state in breach of its duty of neutrality amounts to discrimination against all other traditions. This is from the case SL. So a couple more rules gleaned from this case. If the state favors one religion at the expense of others, it imports a disparate impact that is destructive of the religious freedoms of the collectivity. Big M Drug Mart. Section 27 of the Canadian Charter requires that the state's duty of neutrality be interpreted not only in a manner consistent with the protective objectives of the Canadian Charter, but also with a view to promoting and enhancing diversity, R versus S, 1997. And then they quote Syndicat, to conclude that an infringement has occurred, the court or tribunal must, 1, be satisfied that the complainant's belief is sincere, and 2, find that the complainant's ability to act in accordance with his or her beliefs has been interfered with in a manner that is more than trivial or insubstantial. Let's break down the steps of the analysis here. In this court's opinion, he begins the discussion by establishing the scope of the state's duty of neutrality in the context of freedom of conscience and religion. Then he will go on to consider the rules that make it possible to determine whether the state has breached its duty of neutrality in adopting a statute, regulation, or practice. And then he's going to apply those rules to the facts in evidence that came before the tribunal. So some excerpts from his analysis. The state may not act in such a way as to create a preferential public space that favors certain religious groups and is hostile to others. It follows that the state may not, by expressing its own religious preference, promote the participation of believers to the exclusion of non-believers, or vice versa. The state's duty to protect every person's freedom of conscience and religion means that it may not use its powers in such a way to promote the participation of certain believers or non-believers in public life to the detriment of others. It is prohibited from adhering to one religion to the exclusion of all others. This comes from Section 3 of the Quebec Charter, and this duty of neutrality is a necessary consequence coming from the freedom of conscience and religion in the Canadian Federal Charter as well. The tribunal is therefore correct in holding that the state's duty of neutrality means that a state authority cannot make use of its powers to promote or impose a religious belief. And if a state attempts to adhere to a form of religious expression under the guise of cultural or historical reality or heritage or tradition, it's breaching its duty of neutrality. Because if that religious expression creates a distinction, exclusion, or preference that has the effect of nullifying or impairing the right to full and equal recognition and exercise of freedom of conscience and religion, then there's now discrimination. A provision of a statute, regulations, or even in a bylaw will be inoperative if its purpose is religious and therefore cannot be reconciled with the state's duty of neutrality. So the legislation, its preamble, structure, evolution, context, legislative debate, all of these can be indicators that can be used to delineate the provision's purpose. A typical example of a legislative breach of the duty of neutrality would be a situation in which the state enacted legislation whose purpose was to make the observance of a religious practice mandatory. See the Big M case. In a case like this one that we're talking about, in which a complaint of discrimination based on religion contains a state practice, the alleged breach of the duty of neutrality must be established by proving that the state is professing, adopting, or favoring one belief to the exclusion of all others, and that the exclusion has resulted in interference with the complainant's freedom of conscience and religion. And if a provision, an impugned provision, can still get by if it can satisfy the justification test of Section 1 justification test enunciated in Oakes, which requires a state to prove that 1. That the legislative objective is of sufficient importance in the sense that it relates to pressing and substantial concerns, and 2. That the means chosen to achieve the objective are proportional. So that second requirement has 3 components. 1. The means chosen must be rationally connected to the objective. 2. They must impair the right in question as little as possible. And 3. They must not so severely entrench on the individual or group rights that the objective is outweighed by the seriousness of the intrusion. So this is the Oakes test as cited by Edwards. The judge finds that it was reasonable for the tribunal to conclude here that the city's prayer is in fact a practice of religious nature. Once the tribunal had established the scope of the state's duty of neutrality in relation to the freedom of conscience and religion, whether the practice and the bylaw were religious in nature was a question of fact that fell squarely within the jurisdiction of the tribunal. Its decision on this point was supported by reasons that were both extensive and intelligible, and the Court of Appeal was required to show deference in that case and could not substitute its own opinion on the facts for that of the expert decision maker. I would note that that may in fact be an obsolete standard of review thanks to Vavilov, but that's a subject for administrative law. The judge goes on to say, in my opinion, it was open to the tribunal to conclude that the municipality's practice, given its religious nature, was in breach of the state's duty of neutrality and resulted in an exclusion based on religion. So the evidence shows that the state officials, while performing their functions, engaged in a practice according to which the state professed, adopted, or favored one belief to the exclusion of all others. And the court in SL wrote that a neutral state must show respect for all beliefs, and this includes the right to have no beliefs. The adoption of a practice and of a bylaw by which the state professes and thereby favors a particular religion cannot be reconciled with that principle. So the prayer here was recited by the mayor and the councilors at the public meetings of the council. So there's no question they were performing their functions at the time, and the evidence shows that the practice had a religious purpose, and the tribunal found that. That's their job, which, given that it was a religious practice that the city was displaying, and it was favoring one belief to the exclusion of others. And the court makes a note here that tradition cannot be used to justify such a use of public powers. So easy to say, all this stuff is just tradition, not acceptable. And that the court continues, even if it were accepted that the prayer at issue is a non-denominational practice on its face, it is nonetheless a religious practice, as the respondents themselves conceded at the hearing in the Supreme Court. The respondents argue that in this regard, that a state that is somewhat religious can be tolerated in the context of state neutrality, its tradition, its historical. They said separation of church and state doesn't mean totally separate. The Supreme Court says, no, you're on the wrong track with all of that. True neutrality is concerned not with a strict separation of church and state on questions related to religious thought. The purpose of neutrality is instead to ensure that the state is, and appears to be, open to all points of view, regardless of their spiritual basis. So far from requiring separation, true neutrality requires that the state neither favors nor hinders any religion, and that it abstains from taking any position on the subject. Even if a religious practice engaged in by the state is inclusive, it may nevertheless exclude non-believers. Whether it is consistent with the charter depends not on the extent to which it is inclusive, but on its exclusive nature and its effect on the complainant's ability to act in accordance with his or her belief. So ends Part 13 of the NCA Exam Study Guide for 2023 Constitutional Law. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.